Thanks for joining us here today. My name is Josh Dorcey. I'm the managing partner of the Dorcey Law Firm. We're a boutique law firm that handles estate planning, business planning, and asset protection here in the state of Florida. So today we're going to talk a little bit about Florida domicile. Don't get caught in the weeds. It's, as you can imagine, you move to the state of Florida, it's almost like bringing your passport to the state of Florida. And so we want to make sure as we discuss things today, we're going to discuss stuff that's pretty important to you. And it's making sure that as you move you and your family and your wealth to the state of Florida, that we do our absolute best to protect you, your family, and your estate. And so as we work through the presentation today, we're going to take a little tour on an airboat. And if you've ever been to Disney World or on an airboat, they will oftentimes say, please keep your hands and feet inside the boat at all times. And so at that point, we have the ability to keep you safe. And so this happens to be a picture of my Uncle Jack. He owned Captain Jack's Airboat Tours out on Pine Island for almost 40 years. And so he passed away a few years back, but this just gives me the ability on a timely basis just to remember him, the good times I had on the airboat with him. So as we make a ride through this virtual Everglades tour, keep those hands and feet in the vehicle so that way we keep you safe as we go along. We're going to talk about a few creatures today that have the ability to affect you, your family, and your estate. And the first is the angry alligator. The angry alligator stands for the disability laws of the state of Florida. And so we want to be able to make sure that in the event something happens to you, we have the ability to protect you from an alligator type situation. So in this scenario, when you look at the angry alligator, the fact that it stands for the disability laws of the state of Florida actually has more to the effect of, in the event you ever lost capacity. If you think back before you were age 18, your parents were your guardians. And so when you turned age 18, you became your own guardian, which is kind of unique, right? And so if you get married, does your legal guardian change? And the answer to that is normally no. You actually remain your own person, you remain autonomous, which means after age 18, if you ever become incompetent, incapacitated, or mentally disabled, you're treated like a minor child without any parents, which gives us the situation where somebody would have to do a guardianship proceeding for us. Otherwise, the state of Florida becomes their default guardian. So as we discuss the angry alligator, we're going to discuss the documents that every person over the age of 18 should have to make sure you do not ever become a ward of the state. Now, the next creature we're going to talk about today is the big bad wolf. And the big bad wolf stands for the Florida probate process. And so if you can imagine, the Florida probate process is a process that we adopted in the United States from ancient England because we are based on the English common law. And so probate in itself can be costly, can be time consuming, and it's a very archaic process that we adopted from ancient England a couple hundred years ago. And so if we have the ability to avoid the probate process with our estate, it can oftentimes save our family time, money, and a lot of family feuds. And so if we can avoid probate, we try hard to do so. The third creature we're going to talk about today is the prowling panther. And so, in the Everglades, the Florida panther is protected. It's a beautiful animal. But there's something about a prowling panther, when they're looking into the creek to get a drink, there's always a reflection. And so we look at the prowling panther as the reflection of Uncle Sam, because Uncle Sam has the ability to tax you twice, while you're above ground and when you're below ground. And so when you come in the office, we have a hall of creatures that are beautiful paintings, and one of them is a Florida panther looking into that creek, and it has that perfect reflection of while we were above ground and below ground. And so we want to be able to make sure we can avoid as many taxes as we possibly can. The biggest difference between tax avoidance and tax evasion, I don't know if you know, but if you evade taxes, you get about 20 years in prison. But we're allowed to avoid as many taxes as we possibly can legally. And so our job is to guide you along that way to protect as many of your assets from the claims of Uncle Sam and any state revenue department that we absolutely can. Now, if you've moved here from another state, a high tax state, that state may still have the ability or the want or the desire to tax you back. And so we're going to walk through that in a minute when we look at things from a Florida domicile perspective. The fourth creature we're going to look at today is the unforgiving sharks. Now, the unforgiving sharks are the creditors and the predators out there that have the ability to pursue you and potentially attach or take some of your assets. And so, if you've ever seen a personal injury campaign or a ad on the side of the highway, these could potentially be a unforgiving creditor that could pursue you. If somebody slips and falls on your boat, that could be an unforgiving creditor or predator. And so, oftentimes, our clients are at a point in their life where they don't want to go back to work. And if they are working still, they only have a few more years to work, and they don't want somebody coming in and taking their hard-earned assets. And so we want to put you in the best possible position we can to protect you from those unforgiving sharks. So this is what those four little creatures look like as cartoons, but in the world we live in, they are real creatures, and they really do have the ability to affect you, your family, and your estate. If you've ever had to go through a guardianship proceeding, it can feel like an alligator biting you and pulling you underwater. If you've ever had to go through the probate process, it can feel like a wolf coming after you. If you've ever had to pay excess taxes, that Florida panther doesn't feel so pretty anymore. And those sharks, when they start circling because of a lawsuit, you can very much feel like you're at the end. And so these are four creatures that we very much try to visualize, that we protect our clients from as we work through the planning process. Now, as we work through the Florida estate planning process, one of the biggest elements is clients will tell us that they're going to move to the state of Florida, or sometimes they even tell us they have already moved to the state of Florida. And then they say, I'm a Florida resident, right? And we look at it and say, well, you might not be. When you look at becoming a resident of the state of Florida, it used to be that somebody would come down here and get a driver's license, they would register to vote, they would claim homestead, and they would be here 183 plus days a year, and they felt that made them a Florida resident. Well, the issue is the state of Florida doesn't have a lot of those rules. The states that have those rules are actually the states most people are moving from, the high tax states that people are trying to get away from. And so when we look at becoming a Florida resident or not, it's actually a totality of the circumstances test. So there's a number of different factors, a little over 50 different factors that all the high tax states are looking at, depending on somebody is going to be considered a resident of Florida or a resident of their home state. And so it's not a checklist. It's not something you can go in and just say, okay, I did my 5 or 10 things, therefore I am a Florida resident. If audited, that state has the ability to actually look at a totality of the circumstances and take into account a lot of things that you may not realize they have the ability to take into account. And so we're going to walk through some of those factors today. We're not going to walk through all of them. If you decide you want to schedule a free consultation with us and you want to be able to have that phone call and we can work through some stuff on an individual basis, that's something we can definitely go over, and we have the ability to provide for you our proprietary domicile checklist that our clients receive. And so if that's something you decide to do, once given that opportunity, we can do that on a personal basis. But when we look at the totality of the circumstances, here's some of the factors the states look at. As I mentioned earlier, the 183 plus day rule. Some states have 181, 82, 83. 183 is a pretty good general round rule. But the biggest, keyest element of it all is the state of Florida does not have a 180-day rule. Who has a 180-day rule? Your previous state. The state of Florida doesn't care if you're in the state of Florida 180 days. They just want to make sure you're not in one place more than you are the state of Florida throughout the year. So if you want to travel for a couple months, you can be in Florida 5 months, travel for 3 months, and be someplace else for 4 months, and that would be okay. What the state of Florida does not want is for you to travel for 4 months and you're in your northern state more than you are the state of Florida. That will cause you some complications. And so we have to keep track of how much we're traveling. Sometimes clients will have a primary residence in another state and they'll still have a cottage up on the lake. They don't care which residence you're in. It's as long as you are in the walls of that state for those so many days. It's not where you're at in that state. It's the fact that you are in that state that matters. Now, a nice way to at least let Florida and other states know that you are wanting to claim the state of Florida is kind of like when we landed on the moon and we planted our flag. You can file what's called the Declaration of Domicile in the state of Florida. You file it in the court registry of where you live. And at least from that point on, it lets everyone know for all intents and purposes, you were trying to become a Florida resident. But if you file that Declaration of Domicile and next year you're in another state for 190 days, that piece of paper is not going to do any good. All that's doing is letting them know going forward that you want them to interpret all of your actions in the best possible way that you want to be a Florida resident. But you still have to go through all the different factors to make sure that you're going to become a Florida resident. One of the biggest things they say is they look at where somebody sees their professionals. So that could be your doctor, it could be your dentist, it could be your CPA, it could be your lawyer, it could be your financial advisor, it could be your bankers. They look to see where you see those people at. And so when you look at these factors, view it as, what would a rational person normally do in their hometown? Well, let's say we went back to 1995 and you got transferred in your job to the state of Florida. Well, what would you have done? Well, you would have eventually had a new doctor, a new dentist, probably a new CPA, went out and found a new bank, a new church, a new civic organization, like I'm a part of the Rotary Club, maybe you're part of the Lions Clubs or the Elks Club, or you joined a country club. You would have put down roots. And that's what your northern states are saying is, did you put down roots? Because there's a lot of people in the last few years that have claimed Florida residency, but they actually have never put roots down in the state of Florida. When you look at things on a scale, if you put everything on Florida side and you put everything on their other state side, well, once you add in their doctor, their lawyer, their CPA, their dentist, their money, their house, their car, their northern state oftentimes wins. And so we want to make sure that we're putting enough evidence on Florida side where the scales tip the opposite direction. And so doctors and lawyers, well, what I'll tell you is a lot of times clients will tell me, I have the best doctor in the world up north. Well, if you have the best specialist in the world, then your general practitioner needs to be in Florida. If you have a general practitioner up north, you need to have it one both places. So at least at that point, you can balance the playing field. So at least if they ask where you're seeing your doctor at, you have a doctor in both places. Think about it from this perspective. Who goes to see their dentist when they're on vacation? Nobody. So if your dentist or your doctor or something that by definition would be considered painful is at your vacation destination now, the IRS or the Department of Revenue is going to say that's not the case. And so we need to make sure we're putting roots down in the state of Florida. Now, CPAs are unique because they can typically pass one exam nationally and practice anywhere, but that is a factor that some states look at when it comes down to what your connections are to the state of Florida. Now, we do have a case out of the state of Minnesota that started kind of a trend across the United States where they look to see where your financial accounts or where your banking accounts are at. So to give you an example, let's say you have a Bank of America bank account from a northern state and you moved to the state of Florida and you changed your primary mailing address on that account. By changing the primary mailing address, does that change that account to a Florida bank account? The answer is no. The bank branch that gets credit for your deposits is the branch where you opened the account at. Therefore, if it is a bank account that you opened up north, it is still a northern bank account, and that is a factor that they look at. In the Minnesota case, they looked at every single time the client did a transaction out of that account as a check mark for that state. Well, as you can probably imagine, if you go shopping a couple times a day, that's a lot of little check marks. And so the Department of, or the Congress in the state of Minnesota was lobbied by the banking industry and the wealth management industry. And they asked them to give us clarification on how many factors that's going to count as. And the clarifying language they gave us for bank accounts is that the bank accounts and the transactions cannot be a solely determinable factor. So it's very much a factor, and they're going to look to see how many accounts you have and how many transactions you have, but it can't be the only reason that they tie you back to your previous state. Now, that was Minnesota, but when we have a ruling by a Supreme Court in the United States, those rulings by other Supreme Courts become persuasive jurisdictions for the other 49 states. And so we are seeing now that most states have some form of that factor into their test to see if you're a Florida resident or not. I can tell you in Minnesota, we asked for that exact same clarity when it came to wealth management accounts, and the state legislature purposely did not give us clarifying language on that, which by definition could mean that a state Supreme Court at some point could make the determination that where your brokerage accounts or your IRAs are housed at could be a solely determinable factor. So it's an issue that when you're looking at becoming a Florida resident, I would want to say at least balance the playing field. Have a financial advisor up there, have one down here. And it may take you a little time to build trust in the state of Florida, but once again, if you're audited, you're going to want to be able to show that you have enough evidence on Florida side that there's going to be a victory for a Florida residency. You want to make sure that you have a Florida driver's license, register to vote in the state of Florida, have your vehicles titled here. If you're driving a vehicle back and forth, make sure it's a Florida vehicle that you're driving back and forth, not a northern vehicle. When you are filing your taxes, you need to make sure your CPA is filing you for the processing center for the Southeast. Now, sometimes that's Georgia, sometimes that's Dallas, but you just need to make sure that they are processing it, especially if they're doing electronically. They need to make sure that they are checking you off as a non-resident on your state income tax return. Normally, if you file as a non-resident, that's going to be a trigger for the Department of Revenue to potentially audit you. And so you need to be prepared, have your I's dotted, T's crossed, for once they make that notation that that's in the next few years is a chance when you're going to get that letter in the mail. Your insurances should be based out of the state of Florida as best as you can. So your homeowner's insurance, liability insurances, umbrella insurances, they should be Florida based. You need to make sure that you file for homestead. Now, to file for homestead in the state of Florida, you have to be in that house as of January 1st of the year that you're claiming, and you typically have to file for the homestead by March 1st. And so you want to be able to make sure that you're always setting yourself up, if you want to be able to claim homestead for the first time, that you're going to meet those parameters. Now, when you register to vote in the state of Florida, it is very important that you call your previous registrar where you used to live and ask them to remove you from the voting rolls. That's how oftentimes they will say that they have more people listed to vote in a town than they actually have residents that live there. And so it's very important to help them clean up their voter rolls up north, is when you move to the state of Florida, call them up and have them remove you from the voter registration list. When traveling in the state of Florida or outside the state of Florida, make sure you're using your Florida zip code and Florida address as your primary mailing address. And so I know when you're back up at your cottage, oftentimes the locals will get a 10% discount. So they ask you for your zip code before they swipe your credit card. That is all data mining. Going forward, you're probably going to have to avoid that 10% local discount. Why? Because you're not a local anymore. You live in the state of Florida, so you need to be giving your Florida zip code when that happens. Now, on the next slide here, you want to be able to make sure that your primary mailing address and everything is your Florida residency. And then going forward, you should have your mail forward for the summertime versus having your mail forwarded south for the wintertime. Your primary mailing address with the U.S. Postal Service should be your Florida address. Like I said, make sure that you file for homestead. You cannot file for two different homesteads in the state of Florida. Even if spouses are claiming separate homesteads, that will get you sometimes into an orange jumpsuit or into stripes. And so it's not recommended unless you're under a legal separation agreement that is filed with the court. If you own a business in the state of Florida, that is great. If you own a business in another state, oftentimes if we can move your primary business to the state of Florida, or at least connect you to the state of Florida in some way with your business, that's going to help you as well. We have a case out of the state of Illinois where a family had their full estate planning done in Illinois. They moved from Illinois to the state of Texas. They moved all their relationships to the state of Texas and literally closed the door on the way out when they left Illinois. But they did one thing wrong. They didn't update their estate planning documents. And so when they died, when the family opened the estate planning documents, it said, I am still a resident of the state of Illinois, and I want Illinois law governing my estate plan. And so the Department of Revenue in Illinois used that as a clawback to try to claim this estate for estate tax purposes. The family fought it, and they won, but it was not a ruling that is beneficial to most of my clients, because the ruling said because the family had removed all connections to the state of Illinois did not have a claim. Well, for most of my clients, they're still snowbirds. They still have a house up north. They may have a business up north. They still have kids and grandkids up north. So they are going back and forth throughout the year with that previous state. And so if you are one of those ones that still have connections to another state, it is imperative that you make sure you update your estate planning documents to be able to claim the state of Florida as your governing law, and all of those documents where you have the ability to state over and over and over again that you are a Florida resident. If you have any country club memberships, civic organizations, church memberships, worship places of worship, make sure your primary memberships are here and you have affiliated or associate memberships everywhere else. And so that's just a few of the factors that we see across the state of Florida when people are moving here and across the United States. Like I said, there's about another 25 different factors that we can walk you through on an individual basis. This is just a little article on the Minnesota case, and then a little article there for the Lind versus Department of Revenue, which is the Illinois case that I referenced a few minutes ago. The Minnesota update, that's where I said that the state legislature was lobbied. They gave us the clarifying language for bank accounts that it could not be a solely determinable factor, even though it can be a factor. And unfortunately, they chose not to give us that same clarifying language for wealth management accounts and bank accounts, which does leave the ability for a Supreme Court to make the determination down the road that a brokerage account or IRAs could in fact be a solely determinable factor. In fact, a couple years ago, we had the state of Illinois announce they were looking at taxing non-government-based retirement accounts to come up with their state shortfall. Those non-government-based retirement accounts would have been IRAs and 401ks. And so that is still on the table. No state has made that claim yet. We do not have a ruling from a state Supreme Court, but we have the clarifying language for Minnesota, clearly giving us language when it comes to bank accounts, but did not give us that clarifying language for brokerage accounts, which still leaves that out there, unfortunately. All right. So that gets us through becoming a Florida resident. Now we're a Florida resident, and we need to update our estate planning documents to reflect that we are going to be a Florida resident, and we do not want our northern state to be able to claim us back, at least based on our estate planning documents. And so when we do that, we want to update those 5 ancillary documents that every person over the age of 18 should have. I'm not going to go them in full in depth, but to make sure that you have these, make sure these are updated. We need to have a comprehensive durable power of attorney. Now, our durable power of attorneys in the state of Florida are comprehensive. And what I mean by that is when we typically get one drafted, normally the power of attorney is going to be between 20 and 30 pages in length. And so if you have a power of attorney that's much shorter than that from a previous state or something that you found online, that durable power of attorney is probably not going to have the provisions in it that you need to be in the state of Florida. The next 3 are healthcare documents: the healthcare surrogate, the living will, and the federal HIPAA waiver. Well, the healthcare surrogate, a lot of states call a medical power of attorney or a healthcare power of attorney. This is for general healthcare decision making, which means if you get to that point in life where you cannot make healthcare decisions for yourself, but you're still going to recover, this just allows your agent to step in and make decisions for you in the meantime. But if you get to that point where the doctors have determined that you're not going to recover, you're not going to improve, and you can no longer communicate for yourself, then that's where the living will document comes in. And in our living will, we allow for you to look at a 4th condition in the state of Florida. So in the state of Florida, there's 3 conditions where life support can be withdrawn. It's if you're in a terminal condition, an irreversible end stage condition, or in a persistent vegetative state of which you're not going to recover or improve. Well, that 4th condition I mentioned is actually recognized by states out west, but it's not currently recognized by the state of Florida. But it's what happens if you find yourself in an irreversible brain disease or brain damage situation, like the advanced stages, Alzheimer's or dementia, and you're not going to recover or improve, but you've already deteriorated to the point that you can no longer communicate for yourself. And so in this living will, it's very comprehensive. You're going to go through and pick the provisions that you would want for life support to be able to be withdrawn. Then we go to the next step, and we have 15 things that the American Medical Association considers to be life-sustaining. And you're going to make the decisions, yes or no, I would want that procedure or I wouldn't. That way, when the time comes that your family members have to remove life support, they're not playing the what-if game with what your desires are. They're going to have your exact decisions right in front of them because you made them specifically for them to take away any guilt that they may have if they have to remove life support. Now, the next healthcare document there is the federal HIPAA waiver and release. And as you probably know, when you go to the doctor's office, they make you fill out a HIPAA waiver. And typically, every time you go back, they make you fill out another one. Well, that's the reason behind that is the ones that we sign at a doctor's office or a hospital are typically good for that day that doctor's office or that procedure, sometimes up to 1 year in that office, and then they make you re-sign it. Well, the one that you would sign in our office would be a broad brush HIPAA waiver, which means it's valid in all 50 states. So if you're traveling and you're driving from here someplace else and you get sick, you may not have the ability to sign a new HIPAA waiver in that office. But if your family members have the one that you signed in my office, they have the ability to receive that medical information no matter where you're at. Now, there's a caveat on that. Under federal law, that HIPAA waiver can be valid for up to 2 years after you pass away. Well, that works in 48 out of the 50 states. Unfortunately, California and Florida are the only 2 states that have put a state limitation on how long HIPAA waivers have to be accepted for. So in the state of Florida, doctors and medical professionals only have to accept a HIPAA waiver if it's been drafted or signed within the last 24 months. So this is the only document that we're talking about today that has a time period of when you would want to re-sign it. So that way your family members and loved ones have the ability to receive that medical information. Now, the 5th document is the pre-need guardian declaration. This is the one that allows, in the event that we lose capacity, we don't want the state of Florida to become our default guardian. So the state of Florida lets us name in advance who we want our guardian to be. And so you can actually name in advance who you want your guardian to be. So the state of Florida does not become the default guardian, and you don't have the judge picking a random guardian or a professional guardian. They would pick the person that you have picked. Now, in that scenario, the person you picked has to be willing to be your guardian. So be kind to whoever that you're going to pick. They have to be competent themselves. They cannot be a felon. And they have to take a couple courses under the judge's supervision to make sure they know how to take care of somebody in your condition. So once again, the pre-need guardian is a phenomenal document. It will save time and money if we need it. But in the event that we don't, then at that point, the other 4 documents work for us just fine during an incapacitated state. So that is the angry alligator in the state of Florida. You'll see a little pop up on your screen now. Prior to this workshop, were you aware that the HIPAA waiver has a 24-month limitation in the state of Florida? Click that for me. It's just interesting to see how you guys feel on that, what your knowledge is. All right, I see those answers coming in, and it looks like the majority of you did not know that that was a limitation in the state of Florida. So good. I hope you're finding that information valuable. All right, now we're going to move on, and we're going to move on to the big bad wolf. So the Florida probate process. So the Florida probate process, like I mentioned earlier, is a relatively archaic process that we adopted from ancient England. As you can imagine, the United States used to be a small rural country, and people, when they died, most of their family members lived out on small family farms or ranches. So the kids would get together, they'd ride the buggy into town, they would find the local probate judge, who was in most scenarios one of the local businessmen. The businessman would open the will, see what the debts and obligations were of mom and dad when they died, and the kids would go down the street to the livery stable, the baker, the hardware, all the different grocery stores or whatever, and they would pay the debts and obligations. Then the judge would make sure everybody was being treated fairly and equally, and the gavel would come down, and in most scenarios, the probate was relatively smooth. Well, in today's day and age, most of our kids can't ride into town together all at the same time. None of us know the probate judge personally because there's several of them. And we don't all have creditors that can be found on the same street. And so that same process that we had back from ancient England is an archaic process. Today, it takes a decent amount of time to go through. And so when we look at probate is the legal process of proving your last will and testament. Well, this is pretty crucial because sometimes people have more than one will drafted in their lifetime, especially if you're moving here from another state and you're about to update your estate planning documents. You might have several wills. And so this is the process where the court has the ability to determine which will is truly your last will and testament. In the state of Florida, when somebody passes away, their original last will and testament has to be deposited for safekeeping with the court within 10 days of their passing, because nobody wants that will to get ripped up or thrown away or misplaced. Now, when we go through the probate process, it is a public notice of your net worth. It's public notice of your death, public notice to your creditors. It's the settling of any debts. It's the settling of any will contests, and it's liquidations and distributions of your estate. Well, let's say we were at an all-time low like we were in 2009. Stock market was down and real estate market was down, and the court said that we needed to settle the estate. Sometimes we had to actually sell stocks and bonds when they were down to come up with enough money to pay the debts and obligations of the estate or the taxes of the estate. Sometimes we had to sell real estate when it was at an all-time low because unfortunately we had to settle a claim against the estate. And so when we look at probate from that perspective, probate can cost as high as 6 to 10% of your gross estate. The 6% is the statutory rate, so half of that belongs to the personal representative or the executor. The other half belongs to the attorney or the law firm that is assisting the executor. And then after you add in accounting fees, appraisal fees, inventory fees, etc., oftentimes you can get up to that 6 to 10% number. If we avoid the probate process, we can oftentimes cut those numbers in half, if not more. And in the state of Florida, an average time period for probate is typically 12 to 18 months. So that's from the moment where you pass away to the point where your heirs have the ability to receive their inheritance, 12 to 18 months. Well, that's why you can see on that previous slide, if we needed liquidity out of the estate and the stock market was down or the real estate market was down, we might actually have to sell off assets to pay debts or to settle will contest. Now, prior to 2007, the state of Florida allowed for us to put into our wills and trusts what was called an interim clause or a no contest clause, which said, little Johnny, if you contest my estate, you are hereby disinherited. And so it was a gatekeeper to keep the kids out. Well, in the 2007 Florida Trust Code, they removed that language. They said prohibiting a child to make a claim against the estate was against public policy. And so since 2007, we have seen a much larger increase than we had before of the number of estates and trusts that were contested. And so wills are easily contested. Trusts are not as easily contested. So if you only have a will when you pass away, there is the chance that a will contest could occur. Now, if we can avoid probate in the state of Florida, we oftentimes have the ability to avoid probate in every state. And so to give you an example of that is if you created a trust or some other sort of vehicle, real estate that you own in other states could be owned by a trust or an LLC. When a trust or an LLC owns your real estate, those assets are no longer considered real property in that state. Therefore, we do not have to probate that real estate in the individual states. Otherwise, when you pass away, there has to be a formal or primary probate in the state of Florida, and you would have an ancillary administration in every state that you own real estate. So a lot of our clients that come to us with wills end up with either 2 or 3 probates, depending on where they own their other real estate. The other part is, if we still own real estate in other states, and that real estate is owned in our own names, we normally have to open that probate process in the state where you thought you were moving out of, which oftentimes puts that state on notice that you passed away, which oftentimes can trigger an audit of your estate for estate tax purposes, because it gives that state knowledge that you now have passed away. Well, if you live in the state of Florida and we avoid the probate process, oftentimes that state does not even know that you have passed away. Now, there are 2 primary ways to avoid the big bad wolf. The first is by contract designations. You've probably heard of this before. This would be like joint tenancy on a bank account. So this would be 2 names on a checking account, 2 names on a bank account. It just says that when one of us passes away, it automatically passes to the survivor of the 2 of us. Now, once in a while, somebody will ask us, what happens if I just put my son or my daughter on my deed with me? Will that pass outside of probate? And the answer is yes, but it sometimes creates other issues for us. If you add somebody else's name to your account, number one, if they get sued, the creditor pursuing them does have the ability to go after those assets. If your child or grandchild that you put on the account ends up going through a divorce, there's a chance the assets that you just put in their name could be attached, lost, or taken. The third is from a gift tax perspective. If you put a child's name on your house, by definition, you just gave them half your house in 1 year. Well, in 2022, you can give your child up to $16,000 per year without having to file a gift tax return. But if you just gave them half your bank account or half your house, you actually gave them greater than $16,000 in most circumstances. Therefore, you should be filing a federal gift tax return and notifying the IRS of that gift, and either using your lifetime exclusion amount or paying a gift tax on the amount that's over the $16,000. So even though joint tenancy can avoid probate, it doesn't always solve our what ifs. The other thing that it does is when we give something to our child while we are alive, it is called a transferred cost basis in the asset. So let's just say we paid $100,000 for our house, and today it's worth $500,000. In that scenario, we have $400,000 of gain. If we die today, our children inherit that $500,000 at a cost basis of $500,000. So if they sell it the day after you die, they are not going to pay any capital gains tax. But if you put your child's name on the house today, you just gave them half the house at your transferred cost basis, which means upon your passing, if you owned half the house, they're going to get a step up in cost basis on 250,000, but on the 100,000 or the 50% that you left them or you gave them while you were alive, their cost basis in their half is only 50,000, which means in that scenario, to avoid a 6 to 10% probate problem, we just created a 20% capital gains problem. So I normally don't recommend somebody using joint tenancy to avoid the probate process because it can create other issues for us down the road. Now, other types of contract designations are on financial accounts. So you have payable on death certificates, on bank accounts, checking accounts, savings accounts, money market accounts. Transfer on death certificates are typically on stocks and bonds and mutual funds. And then beneficiary designations are typically going to be on life insurance, annuities, IRAs, and 401ks, and other types of qualified retirement accounts. Now, in those scenarios, you can name a direct beneficiary to receive those assets upon your passing, and those will automatically vest in the beneficiary when you pass away, therefore avoiding the probate process. Now, in that scenario, if your child or grandchild or heir is in the middle of a lawsuit, a bankruptcy, a divorce, a creditor dispute, a long-term disability, those assets have the ability to be immediately attached, lost, or taken by a third party. In fact, in 2014, the U.S. Supreme Court ruled in what's called the Ramaker decision that when a child inherits an IRA, it goes from an individual retirement account to an inherited retirement account. Upon the switch to an inherited retirement account, those retirement accounts lose federal creditor protection, and then general creditor protection is depending on the state of where the beneficiary lives. And so oftentimes you could be leaving a very large IRA or 401k to a beneficiary and very much leaving them in a situation where that IRA could be attached, lost, or taken. And so it's not recommended, even with IRAs or 401ks, to leave them by way of a beneficiary designation. Now, the second way to avoid the probate process is to use a Florida revocable living trust. Now, there are revocable trusts all over the United States. The reason I point out Florida here is sometimes Florida has different ways of doing things than other states, and sometimes they're better than the way other states can do them. And so by making sure that we have a Florida revocable living trust, we were able to state in there that you want the state of Florida governing your estate upon your passing and your incapacity, and it allows for us to move your estate plan under the laws of the state of Florida and do everything the Florida Trust Code allows for us to be able to do. Now, how does a trust work? In this scenario, a revocable living trust is by definition a will substitute. You're able to create the trust while you're alive. Some people will call it a living trust. The reason we call it a living trust is when you die, anything in your own name has to go through probate. But if you die and you don't own anything, then there's nothing to probate. And so the trust itself never dies. It goes on living. So it actually avoids the probate process. And so while you're alive, working with an estate planning attorney, we are able to set the trust up. You are the trustee, so you're in 100% control, and you are the primary beneficiary while you're alive, which means you can buy, sell, liquidate, spend it all, give it away. It's yours. But what you've done is you've basically just performed the probate process while you're alive with your attorney instead of waiting for the court process to have to do it upon your passing. Now, the only way for a revocable trust to avoid the probate process is your assets actually have to be inside the trust while you're alive, or they have to be directly aligned by beneficiary designation or contract designation to flow into the trust upon your passing. So this is one of the areas that sets our firm apart in Southwest Florida. There's a little over 170 law firms in Southwest Florida that claim they do wills, trusts, and estate planning. There's only 2 of us in Lee County and 1 in Collier County that I'm aware of that has full trust funding departments, which means we work with our clients to make sure the assets actually make it into the trust. We don't just send you home with a to-do list at the end. So if you have a previous trust, my first question to you is, are all of your assets titled in the name of your trust? You should know this by your bank statements, and brokerage accounts should be coming in the name of your trust. Every piece of real estate you should have should be either funded or aligned to flow through your trust. Your life insurance, all those assets should be flowing through some form of your estate plan. And so if you have previous estate planning, but you don't have the trust funding in place, that's something that we will review and analyze with you if you decide to have that free consultation with us. Now, this is what a basic trust works like. And then upon our passing, we can set up and pass assets on for the benefit of our kids and grandkids, and we can provide as much asset protection as you want for those beneficiaries. Now, let's say you have a little bit more of a complex estate. So a taxable estate today in 2022 is a $12,060,000 estate. If it's a husband and wife, it's going to be a little over the $24 million amount. Now, we're going to talk about this a little bit later when we get to the Prowling Panther, but the estate tax laws are very much in flux. And so there's a very good chance that that may change over the next few years. And it could go down as low as $3.5 million per person, or as low as 6.5 or 6.5 million per person. So that's something to keep an eye on. That don't be too comfortable with the $24 million amount, because that may be going away. Now, oftentimes we will see that a more complex estate may also include a blended family type situation, where this is a second or third marriage. You want to be able to make sure you take care of your surviving spouse, but you also want to be able to make sure that the money that you have made makes it on to your respective children. And so inside the trust, we can build in those parameters. We can protect the surviving spouse, provide income for the surviving spouse. We can also make it where, in case the surviving spouse found new companionship, which we do see often, that it is a requirement that if that new companionship was going to turn into a new marriage, that the surviving spouse would have to sign a prenuptial agreement with that new person, making sure that new person cannot come after any of the assets that you have built during your lifetime. Here's something that's unique. In the state of Florida, if somebody gets married without saying I do, the new spouse is given a guaranteed right of, in essence, 50% of your house or a life estate in your house and 30% of the rest of your estate, just by saying I do. And so the prenuptial agreement for late stage marriages is a great way to provide for a surviving spouse, but also make sure that there's not going to be a new person coming into your surviving spouse's life that's going to convince them to leave all the assets to a different family. And so we have the ability in a more complex trust to be able to provide that protection for the benefit of your kids and your family and your heirs. And then when we get down for the benefit of our beneficiaries, there are different ways that we can leave assets for the benefit of our kids. Now, statistically, about 80 to 85% of the trusts that walk in our office, they have what's called outright distribution in their estate plan. Outright distribution means the trust was really designed to avoid probate and maybe probate and some estate taxes, but the trust wasn't designed to provide any asset protection for the heirs or beneficiaries. What this means is immediately upon mom or dad passing away, the assets are going to automatically vest in the benefit of our beneficiary. This is no different than a contract designation in this scenario. So in the event our beneficiary is in the middle of a lawsuit, a bankruptcy, a divorce, a creditor dispute, or a long-term disability, those assets have the ability to be immediately attached, lost, or taken, where a third party could actually take those assets from your beneficiary. We happen to live in the United States where roughly 50% of all marriages end in divorce. While the estate tax really affects 1% of America, what I'm going to call the divorce tax affects roughly 50% of all marriages. And outright distribution does not protect your children or grandchildren or heirs from divorce in this scenario. So even though most people come to us with outright distribution, when shown other options to provide assets protection for their beneficiaries, most of our clients seem to pick a different option. Now, the second way that we look at a trust is what's called a discretionary holdback. This is where you still have outright distribution in your trust, but you want there to be one chance for us to have a crystal ball. So if upon your passing, your child was going through one of those creditor disputes, we want to be able to hold back that distribution during that time period in the child's life. In this scenario, you need to have co-trustees, or you need to have an independent third-party trustee making that decision. But it does give us the ability to have a one snapshot immediately before we make a distribution to make sure a child is not going through a lawsuit or bankruptcy or divorce or creditor dispute or long-term disability. Now, once that issue in your child's life is over, they will eventually receive that distribution. And so if something happens after the fact, the cat's out of the bag at that point. We were given a one-time opportunity with a holdback provision to give that protection for our beneficiary or our heir. Once that issue is over, the trust would typically make that distribution to that child. And once again, the cat would be out of the bag. Now, the third way that we would look at a trust is what we would consider to be a lifetime or dynasty trust type scenario. And there are many different ways to set this trust up. I'm going to cover a few basic examples of them. And if we sit down on an individual basis, we will gladly walk you through the different options. But in this scenario, instead of leaving the assets to your kids outright, you're leaving to them in an asset protected trust. You're giving them a trust that has the ability to protect their inheritance for a total of 360 years after your passing. And if set up as a generation skipping tax trust, it has the ability to avoid the estate tax and the generation skipping tax for roughly 100 years after your passing. So in this scenario, if you leave the assets into the trust for the benefit of your child, you can give parameters of how your child can pull it out. You can say they can spend as much as they want on their health, their education, their maintenance, and their support. This allows for them to pull those assets on their own without a third-party trustee and still provide some levels of general needs creditor protection. Oftentimes, the way we will set the trust up is we would utilize laws of states better than Florida. Typically, we would use either Nevada or South Dakota law upon your passing for the trust that you're leaving for the benefit of your kids. In this scenario, we can take advantage of Nevada or South Dakota law, where they have the best divorce, alimony, and child support protection for the benefit of your kids. But to give you a theory, so in this scenario, you see the two different buckets sitting in front of you. If your child pulls the money out of the trust on the right and buys a house in their own name, if for some reason they get sued or their marriage ends down the road, there's a good chance that house would be included in that lawsuit or in that divorce, and it may even have to be split. But in the bucket on the left, if your child had bought that house inside the trust that you had left them, that house is now an investment of that trust. And if their marriage ends, there's a lawsuit or bankruptcy, the assets inside that trust are fully protected. And then once your child or heir passes away, it passes on to the next generation with the same level of asset protection. From our perspective, there's not a better way to leave assets for another generation than to provide them some layers of asset protection, especially as our society is becoming more litigious. So, like I said, most people come in our office with outright distribution. Our clients, once given these three different options, around 85% pick either the holdback or the lifetime or dynasty trust. And so we will always walk you through different ways to protect you and your family and your heirs. It's always up to you, the choice that you decide to make or the level of protection you want to give them. But we want you to have those options, and then you can make the decision of what's going to be best for your family. Now, when you create a trust, there's oftentimes a question that I get asked, and that is, Josh, if there's a change in the law, is your firm going to reach out to me and let me know there was a change in the law? Well, the traditional attorney-client relationship is what we call option 2, a la carte. That means once you hire us and we draft everything up, once everything's drafted, our job legally is done. The Florida Bar says at that point, we were hired for a limited engagement, and at that point, you leave and we tell you to call us back every 3 to 5 years, and we can do a review and an update at that point, depending on what your circumstances are. Well, about 8 years ago, I had a couple clients that reached out to me and said, Josh, you guys did a great job drafting the trust. You did a great job funding the trust. And then you sent me home to read the Wall Street Journal and the Florida Bar Journal and to wonder every time I heard something about taxes in the news, wondering, does it affect me? So isn't there something you can do that's different? And so at that point, we created what we call autopilot planning, and is our ongoing continuous relationship with the clients that choose to have that relationship. In that scenario, you do pay a fee to be a part of that program, but we audit your file every year. We follow up with you on constant funding of the trust assets to make sure everything is kept inside the trust. And in the event there's any particular needs while you were still alive, we are constantly notifying you when there's statutory changes and case law changes to be able to make sure if we have an untimely demise that the last time I spoke to you was maybe 6 months ago instead of 3, 4, 5, 6 years. And so once again, that's always your choice, but we have both of those programs in our office, and you have the ability to join whatever one that you would rather. The Florida Trust Code, as I mentioned earlier, came into effect in 2007. We still have a lot of clients that come in from the late 90s and early 2000s that have trusts. We just want to be able to make sure that if you have trust before those times, they do need to be updated to the current statutes to be able to take advantage of what the Florida Trust Code allows for us to do. Now, you'll see a little question there. Is avoiding probate of your estate a concern to you? Put yes or no there, once again, letting us know if that's an important factor for you. All right, I'm starting to see answers coming in, and it looks like overwhelmingly avoiding probate is very important to you. The next question that we're asking there, how important is it to you to protect the inheritance you are leaving from lawsuits, bankruptcies, creditors, and divorces? So this is protecting your kids and grandkids from lawsuits, bankruptcies, creditors, and divorces. On an overwhelming majority, I'm seeing a lot of 7s, 8s, 9s, and 10s. Very few of you don't care at all, but for the most part, it seems like everybody very much wants to protect their heirs. In that scenario, that third option is normally going to be one of our better options, and then we can design that for what's best for you, your family, and your heirs. Now, as we move on to that third creature, which is avoiding the prowling panther, this is that Uncle Sam getting you above ground and below ground for tax purposes. This will go relatively short and sweet because if we need to meet on an individual basis, we can go much more in depth. Now, in 2025, the federal estate tax exemption, like I said, is going to drop based on the current sunset provisions. So today, the exemption's at $12,060,000 per person. And if somebody does pass away, we need to file an estate tax return to be able to claim that portability so the surviving spouse can have both exemptions. If you've had a spouse that's passed away in the last 2 years and you did not file that, the IRS has allowed for a grace period for portability, but it must be filed within 2 years of the date of death of the first spouse. So if you haven't done that and that's important to you, please reach out to your CPA or our office and we'll gladly get you connected with somebody that can file that for you. Now, after 2025, it comes back right now in 2026 at roughly $6 million per person. In the last congressional cycle, we saw that they looked to lower that prior to 2025 and 2026. And so we very much expect that in the next couple of years, we may have some volatility in that section. So if you happen to fall on that or above that, that level in your state, that's something that you need to stay in very much contact with either us or your estate planning law firm. Now, the current exemption is growing at roughly 3% a year. And when it goes back to 6 million, it will still have an inflationary growth factor built in. Like I said, for portability purposes, you need to make sure you file that estate tax return. If you haven't, it's very important that you do so. And then by living in the state of Florida, as you know, we don't have a state income tax. However, we do have a corporate tax. So if you're a C corporation in the state of Florida, we do have a little tax. It's a 5.5% tax, but it's still one of the lowest in the United States. So it's still a very, very much a tax-friendly state from that aspect. Now, the last creature we're going to talk about is avoiding the unforgiving sharks, the creditors and the predators that have the ability to pursue you, your family, and your estate. And so I'm going to go through a little bit of a T-chart here. If we sit down in person, either me or one of our other amazing attorneys will walk you through the full T-chart analysis of what you have that's protected, what you have that's not protected, and then work with you if you want to make the non-protected assets protected. So on this T-chart, on the left-hand side, these are the things that are protected by Florida statute. The first is your Florida homestead. So as long as you pay your taxes, pay your contractors, and pay your mortgage, nobody else can take your house from you. Your 401ks, IRAs, Social Security checks, and pensions are protected in the state of Florida for you. But like I said, when you pass 401ks and IRAs on to the next generation under the Romaker decision, they do not have that same federal credit protection. In the state of Florida, life insurance and the cash value of life insurance is fully protected. Annuities and annuity streams. So annuities have the good, the bad, and the ugly. But when it comes down for asset protection, the state of Florida protects all the annuities and all the annuity streams. So if you remember O.J. Simpson received very good advice after he received the judgment for the civil lawsuit. He bought a condo in the state of Florida. He had a pension and annuity stream from the NFL. And at that point, they could not take his income stream and they could not take his house. So you don't have to like the guy, but that same protection applies to you in the state of Florida. Foreign business entities can be protected in the state of Florida. And what I mean by foreign is that means LLCs or corporations created in other states are still recognized in the state of Florida. If you're still working and somebody has a garnishment order against you, you can set up what's called a wage account or a household account. And then if you're married in the state of Florida, we have a protection called tenancy by the entirety. We're one of the few states in the United States that allows for that protection to apply to all types of assets, tangible, intangible, and real property, while most states just apply that protection for real property. It's something we can go over on an individual basis, but it does provide a very nice level of asset protection for married couples. Now, on the non-protected side, this is non-homestead real estate. So this is something that's not where you're primarily living. It might be in the state of Florida, or it could be in another state. What's also not protected is your stocks, your bonds, your CDs, your money market accounts, your mutual funds that are not inside an IRA or 401k. Most Florida business entities do not have great asset protection. So once again, if we're setting things up from an asset protections perspective, we would oftentimes use either Wyoming or Nevada or Delaware for business entity purposes. And then when you look down at the bottom, assets that you own as joint tenancy, tenants in common, and community property do not provide any asset protection in the state of Florida. So one of the easiest things I can have you do is when you sit down, add up all the money you have on the protected side, add up all your assets on the non-protected side, put a big X over the non-protected side, and ask yourself, if the worst thing happened and you lost everything on the non-protected side, could you live on just the money on the protected side? If the answer is no, then when we sit down on an individual basis, me or one of our other attorneys will gladly walk you through how we can assist you in moving assets from the non-protected side to the protected side so those assets can still be protected during your golden years. And so from an asset protection perspective, it's very, very important. Just because somebody has a living trust does not mean they have asset protection. Oftentimes people have a misconception. A living trust does not provide any asset protection while you're alive. It is a revocable trust, it is a living trust, and it is designed to avoid the probate process. So if you have a trust and it's revocable, it does not provide you any asset protection. That's why we would need to sit down and look at how we can provide protection for those assets. Oftentimes people will tell me that they have an LLC to own real estate. The biggest question I'm going to ask you is, if you own an LLC and you own real estate, or you have other assets in an LLC, if you got sued today and a judgment was put against you, how are you going to get to the money inside the LLC? In most scenarios, the client and even the attorney that set up the LLC did not give a valve for being able to get the money out of the LLC. You see, an LLC provides great creditor protection. It's called a charging order protection. It means if you are sued personally and you own assets in an LLC, that creditor cannot pierce the veil and get inside the LLC and take over your company. But it also means that if you take a distribution out of that LLC during the time period of that judgment, you have to satisfy that judgment, which means most people don't have a plan of how they're going to be able to access that money. The LLC is going to freeze your money, but how do you get to it? And so on an individual basis, we can walk you through a number of strategies that we've been able to develop and use over the years to make sure our clients can actually touch those assets, live on those assets, and spend those assets in the event that lawsuit comes. So as you see on the screen, you have the spot there to be able to schedule a free consultation with us. This is a quick 25-minute phone call with me or one of my other attorneys, and that way we can walk through some more personal elements. If at the end of that phone call it is warranted, we will offer you a free hour and 15-minute consultation to come into the office. If you have previous estate planning documents, we will gladly review those for you, so that way we can give you the advice and counsel and if you need to update to the state of Florida or not. Now, when it comes from an asset protection perspective, if you get that letter in the mail from one of those personal injury attorneys, unfortunately, at that moment, it is too late to do asset protection. And if we start moving things around at that point, that falls under the federal fraudulent conveyance statutes. And that means you and I both have the ability to be held civilly and criminally liable depending on the actions. And I don't know about you, but I don't look good in orange and I don't look good in stripes. So we would much rather do proper planning upfront. So if that worst case scenario comes, you're already protected and we don't have to worry about your family, your estate, or your assets, because we put this plan in place a long time before you receive that letter in the mail. So as you go throughout your day today, just remember these four beautiful creatures: the angry alligator, standing for the disability laws of the state of Florida; the big bad wolf, which is obviously the Florida probate process; the prowling panther, which is Uncle Sam, for tax purposes; and then those unforgiving sharks, those creditors and predators that have the ability to affect you, your family, and your estate. I hope you guys have a great day, a great year, and we look forward to meeting with you.